Let me swear the witness in, Madam Arbitrator.
Yes.
George, if you'd raise your right hand, please, so we can see. Thank you. Do you solemnly swear that all the answers to all the questions now to be asked of you, just and interest in this matter, be the truth, whole truth, nothing but the truth, so be good?
I do.
Thank you. You're sworn.
Great. Would you, Mr. Polari, would you please introduce yourself to the arbitrator?
My name's George D. Polari.
Okay, and if you could get a little bit closer to your mic, or you're coming in and out a little bit. Is that okay? All right.
Good.
Excellent. Can you just very briefly describe your current position and your role at Alvarez and Marsal?
I'm a managing director at Alvarez and Marsal
No.
Caring Group.
No.
Maybe this is too.
No. Well,
Do you want me to?
All right. Just give us a second. I'm trying to figure out what the problem is because you're coming in and out. Let's try it again.
Okay, I'm a managing care industry group.
no.
Alvarez and Marsal.
I'm sure you said managing director, but I never heard it. So, but I'm not going to make up the testimony either. And I'm going to transcribe.
Managing director.
Yeah. All right.
Are we off the record or still on?
Let's just go off the record real
Can
quick.
you move the box around a little bit and just see if it makes any difference?
Maybe it's not close enough.
Yeah.
Close enough to over there,
Because you got
maybe?
Bluetooth going on.
I'll say one thing. And then I hear it in your room.
He hears what?
Yeah, you're coming in. Here, why don't we do this? Let's see if we can run off the speakers here. Hold on. All right. Can we hear you now, George? Can you hear us now, George?
Loud and clear.
Let's try it again. Can you hear us?
Yes.
All right, let's try that.
You may need that microphone moved over there.
Yeah. Is there any way for you to put the computer on the table?
Oh, let's try it. That's about
not
as far
gonna
as it
reach.
goes.
All right. Well, let's
Sit
do
it in a
that.
chair. Move
Yeah,
the chair
just-
back there and sit it in a chair.
Sure, yeah. That'll move too, okay.
Pull that wire up under the, there you go.
Put that up.
Where's
near
the speakers?
Put the Scotch tape right up there by the speaker.
The speaker's right here.
Yeah, I think it's right. Yeah, I think it's on either side.
Okay. George, say Mary Had a Little Lamb. Just talk for a sentence and a half.
Okay, this is a sound check. Hope it works.
Okay.
All right, that's better.
Okay, we're good.
All right, we'll go back on the record.
All right, go ahead.
Okay. George, thanks for your patience. Can you just tell the arbitrator quickly what you do in your role as a managing director at Alvarez and Marsal?
Yes, I work generally with companies that are distressed or under some degree of stress. Typically, they might be running up against loan covenants or they're short on cash and they need some kind of solution to best preserve value for the different constituents.
Can we just have to go back into the record where we did not get the full answer? What is his officer or whatever position in the company, please? Because I did not get in that record.
What's your current position with Alvarez and Marsal?
Managing director, and I'm co-head of the West Coast healthcare team.
Thank you.
Have you frequently served as a chief restructuring officer?
Yes.
About how many times have you served in that capacity?
Perhaps a dozen or 2 dozen, something like that range.
Can you explain, do you have a particular expertise in the healthcare field?
Yes, I've been in healthcare as a senior executive for more than 30 years.
Can you explain to the arbitrator how you first got involved with Restora?
We were involved with Restora early in the discussion between the owners at the time and the lender. And I think people wanted to have some kind of independent evaluation of exactly where the business stood. This is common in our work where we're brought in as something of a trusted third party, although we're hired usually by the company, and in this case we were hired by the company. The lender, or if there's another outside investor, typically to a certain degree rely on our work to help them judge how well the company is doing.
And in this particular case, do you recall when you were contacted to serve as a chief restructuring officer around the November 2013 timeframe? Is that about right?
Yes, yeah, that's correct. And this engagement started out like many of our other engagements, where we're brought in on a consultative basis to help create an evaluation of the situation that all the constituents can look at and then together decide on next steps. The situation then lent itself to us becoming the chief restructuring officer soon thereafter.
In connection with your role as the chief restructuring officer, did you engage in discussions with the lender in this instance?
Yes.
That was HFG.
Yes.
And did you or members of your team have regular discussions with them about the plans to preserve value?
Yes, there would have been at least a weekly call, perhaps more so. I don't recall exactly, but typical protocol would be to at least have a weekly call to review cash disbursements, cash receipts, and any change to what I'll call the baseline outlook, which generally refers to, how far can the company go under its current expense and receipt structure with the cash it has on hand. So when will we run out of cash? When will something have to happen? And that's reviewed every week, typically, sometimes more than once a week, but at least once a week.
In this particular case, you were engaged in November 2013. Were you involved in exploring different options for the company?
Yes. Well, we're not investment bankers. Our job is to either hire an investment banker or help the company hire an investment banker, or if there isn't the time or the resources available to run a typical process, which generally takes 3 to 4 months to survey every possible buyer out there and so on. We'll many times help the company reach out to known suspects, people that are competitors or people that have previously expressed interest in the company, and we'll help facilitate discussions with those parties to see if somebody's interested in either making an investment or acquiring the company or doing something that would transform the situation into something more favorable.
And did you discuss those types of options with HFG?
Yes.
And did you discuss those types of options with the management group and the ownership group at Restora?
Yes, and many times these discussions all happen in the same room, if you will, or the same virtual room, on a conference call.
And do you recall in this case whether different people on the management team and different people with your organization went out into the market to try to find people to help with a solution for the Restora issues?
Yeah, I think everybody did their best to chip in and go to, like I would call it, the list of likely suspects, and see what kind of interest could be stirred up.
And do you recall whether there were particular, I'd say, targets or potential partners such as Cornerstone? Do you remember Cornerstone at all?
Yes.
What
Yes.
do you recall about Cornerstone?
Cornerstone expressed interest, but I think that when it came right down to it, they were not ready to do a deal.
And how about Solterra? Do you remember Solterra?
Yep. Like many participants in a process like this, a lot of these guys express a lot of interest up front. They want to get themselves in the process and under consideration. But when it comes down to, in effect, signing on the dotted line or making a hard commitment, they also dropped away.
Do you remember having discussions with the landlord, ARC?
Yes, many times.
And what did you discuss with ARC at the beginning of the process? Did you talk to them at all about trying to get a rent abatement or anything like that?
Yes.
What do you recall about that?
I don't recall specific details. There may be emails or documents that do that, but typically the two biggest expenses in any company are going to be its real estate expenses, its rent, and its labor expenses. So I could remember having early discussions and many discussions with ARC about what to do. I think in the end, ARC was willing to create some accommodations as part of a deal, if I remember correctly, because they had an interest in keeping rent flowing from the buildings, over the 10 or 20-year period that they were to own them.
Do you remember having discussions? Did you bring Tutera to the table?
Yes.
And can you tell the arbitrator who Tutera was?
Tutera and Company is an organization that owns and manages these types of facilities, nursing homes, LTACs, and others. They've been around many years, and I had personal experience working with Tutera on a different deal, and remembered their interest in this space. Had run into them occasionally over the ensuing years, but they were one of the list, as I said earlier, of likely suspects, people who knew the space, who might even have known the properties, and who could move quickly to do something before the company ran out of cash.
Did you explore other options, such as trying to buy the note from HFG?
I think every conceivable option was explored. The issue here was the lack of cash resources and the lack of the ability to monetize assets. So what I mean by that is sometimes if a company is cash poor, but it had assets that it owned, if it still owned the buildings, for example, we could have done a sale leaseback and generated cash. We would have created rent expense, but we would have generated cash to allow the company to continue to operate. We didn't have a whole lot to work with when it came to those kind of things.
So, I want to. You may not have these things in front of you, but you get involved in November of 2013. There was a bankruptcy filing at the end of February 2014. So we had a period of a couple of months in there where you were involved in looking at these options. During that period of time, you said you were in discussions with HFG. Were there, what was the general discussion with HFG about kind of time frame and options on what you could do and when you had to do it by?
One of the biggest issues facing a company that's in default or near default or in extremis, like this organization is that the lender has remedies, and the remedies can be pretty harsh. So the lender, if it decided to exercise its remedies, it could, for example, force acceleration of payment. meaning you owe us the entire loan back today. And in doing so, would force the company essentially to close down. It would be able to take all the cash legally and force the company to close down and even have a lien on future receivables, depending how documents are written. So, one of the first things like a CRO is supposed to do, in this case, I believe we did it, is to sort of get everybody to stand down. So we were able to convince the lender that we need a little bit of time and a little bit of money that they would fund in order to determine if there was a market deal to happen, if there was going to be an acquirer or a new investor in the company. And I think we agreed that the lender would give us something like 4 to 6 weeks, and if that wasn't the case, then we would file a bankruptcy and look to recover what we can for the lenders through a liquidation. And that played out through the month of January, where we got a couple of guys to the table, got them close, and then a deal came together that involved the lender and others to allow the company at least a shot at a future, and that's what was filed as the stalking horse.
And before we get to the stalking horse, I just want to say at the beginning, you were looking for a market deal, a sale, something that would generate value, correct?
Absolutely. That would be always, in almost all cases, the best answer.
And in this case, for whatever reason, despite a couple of possibilities, that just did not come to pass, right?
Correct.
When you came in as the CRO, did you have a discussion with the management team and with ownership about what happens when you have an insolvent company on the edge of bankruptcy?
I most certainly had that conversation. Whether I had it the minute I came in as CRO or whether it happened, over the ensuing weeks, those conversations happened because the last thing you want to do is you don't want to mislead people. And if I know for a fact that people aren't going to be entitled to severance or contract provisions that they have in employment contracts, it's better to have that discussion out in the open up front with them rather than have it be a surprise on an eve of a filing.
And to be clear, very early in this process, you brought in the law firm of DLA Piper as bankruptcy counsel, correct?
Yes, technically I recommended them and the owners hired them, yes.
But just the original contact with Mr. Califano, that was your contact, correct?
Yes.
And did you receive requests from ownership or management for expense reimbursement that were rejected?
I don't recall exactly, but I know that generally when you're an insolvent organization, as this organization was, this is now in the December, January, February pre-filing period. You must be pretty careful about how expenses go out to any insiders, and if expenses were current expenses for recent travel and things like that, those generally get reimbursed. If they're for unusual items or they're items that were more than a certain period ago, generally we don't reimburse those because they would be clawed back as preference items in a bankruptcy filing and create litigation for the participants.
So now I want to talk for a moment about the actual preparation of the bankruptcy filing and not focus on the false starts, whether it was the one with Solterra, but talk about the actual stalking horse bid that was put together. how did that come to be? Do you remember when you had Acuity and Tutera and San Monica? Do you remember that?
Yeah, I mean, all of those parties had a vested interest in keeping the business going in some way, whether it was to preserve something they had or whether it was to seek future gain. They all had some kind of interest to make things work. And I think we iterated on the discussion a couple of times on what each party could do, and got around to something that was at least acceptable, to that group as far as the capital and the splits and everything else.
Was there a goal here to have an auction process and perhaps bring in or entice another buyer to acquire this?
We would have hoped so. It's a lot easier to get a deal done when you have another deal in hand. So generally, when a company is looking to sell itself through a bankruptcy process, it's generally a rule that it's better to have a stalking horse bid in hand to put on the table to see who else would want to top it. Without a stalking horse bid, you basically play a waiting game to see if people show up, and if they wait you out trying to get the company in its most distressed state, many times that doesn't really play out. But to get a robust competitive situation, having the stalking horse in hand is the general guideline that you want to follow.
Do you recall in this particular case, on the eve of bankruptcy, the events leading up to that filing of the bankruptcy on February 24th?
Yeah, I think what you might be asking about is the actual filing of the petition, which generally requires board approval. The actual signatory on the petition is just an authorized signatory on behalf of the board, whether that's a board member or another officer. It doesn't matter. But board approval was, I believe, difficult to come by in this case, and there was some disagreement over what to do.
And so I'd like to talk a little bit about that disagreement. Did you ask Mr. Laughlin to approve the bankruptcy filing?
Yes, I mean, either I or one of my colleagues, circulated documents to the board that we would have asked for board approval, like we do on most everything, in order to move ahead.
Did you have a discussion with Mr. Laughlin about HFG's patience with the process and their willingness to continue funding?
I'm sure I had at least one, if not many, discussions with Mr. Laughlin and all the parties involved about how we were essentially given a week-to-week lease on life from the lender.
And did you understand that if the lender cut off funding, that would have bad consequences?
Yes. The company then would likely be turned over to a Chapter 7 trustee who would liquidate the assets and return it to creditors according to the creditor waterfall.
Was there a concern about an inability to make payroll and take care of patients if the lender cut off funding?
Yes, and that was one of the pieces of leverage we actually had with the lender. To overnight shut down a healthcare facility is a messy situation with all kinds of issues like you're alluding to. So the plan was to the worst case was some kind of gradual wind down of the business so that patients could be transported and moved out and we wouldn't have issues there. And to the extent you can avoid issues with payroll, that always is healthy, since that affects many people, but also payroll is a hotspot for liability back to all the parties, lenders, officers, directors, and everything. So we try to protect those two things best we can.
And did there come a point in time when HFG said, look, we've given you, we've given you some rope here to try to come up with an alternative solution, but you're out of time, you're out of rope?
Yes.
And can you explain to the arbitrator, in your opinion, did HFG do that precipitously?
No. HFG was a good actor here, if there could be a good actor in a situation like this. From their perspective, they had significant capital at risk, and they behaved correctly in that they did not want to see an overnight shutdown and all kinds of patient safety issues pop up. To the extent payroll could be protected and people weren't misled into coming to work and not being paid for a few weeks, they understood that issue. And I think we developed detailed plans for an orderly wind down of the facilities, and that was always on standby should a deal not be reached. So HFG gave us enough time to do a quick and dirty survey, for the owners and for others to figure out if there was a deal out there. Again, I don't think there was the resource available here, the cash available to do a full-blown, 3 to 4 to 5 month investment banking process. But the organization and the players did the best they could in the time frame. And HFG, I really can't complain about their behavior.
And then, but when they finally said enough was enough, then did you feel like you had a choice but to file the bankruptcy?
No, there was no choice, because what happens is that the difficult thing with an insolvent company is getting money into the company. So if you put money as an investment into an insolvent organization and it files bankruptcy the next day, you just invested in equity that's way at the bottom of the waterfall when money comes out of the company someday to creditors. HFG, as the senior secured lender, was, the only way it would put money in if we needed money for payroll was if the company was in bankruptcy, so that they would see the priority change, where they would see their senior secured loan improve and be more of a first in, first out kind of situation with the money.
So, in short, at the end of February, they agreed to continue funding payroll, but you had to file the bankruptcy petition.
Yes.
And when you raised this with Mr. Laughlin, did he have any conditions or demands as far as consenting to the bankruptcy?
I don't recall specific discussions, but I think there was a lot of interest in personal severance agreements and employment contracts, because what happens in a bankruptcy, just to make sure everybody knows this, is one of the things the company can do in bankruptcy is decide to reject or void certain contracts it has. And usually many of the first things to be rejected are employment agreements that have severance and things like that, because paying such agreements in a bankruptcy would be paying for things that don't benefit the creditors at that moment, or in the forward picture of a bankruptcy.
So, was the company in any position to be paying severance payments to its senior management?
No.
And as a result of Mr. Laughlin's refusal to authorize the bankruptcy filing, what happened next? Let me back up. Was that decision, in your opinion, in the best interest of the company?
It was, yes. It was in the best interest of the company and all of its constituents.
Just to be clear, that what you're referring to is the termination of Mr. Laughlin, correct?
Yes, since that then allowed the filing to happen. Without the termination, I don't know if they could have, the board vote needed to be in place to authorize the bankruptcy filing. And his refusal to vote for it prevented that from happening. So his termination allowed the board vote to go forward and allowed the company to get into bankruptcy and at worst secure a future, which meant a gradual wind down and people being paid for time they worked. And at best, it meant emerging with new ownership structure.
And taking a look at it from the other perspective, was, in your opinion, Mr. Laughlin's demand for the payment of a severance and a refusal to approve the bankruptcy, was that in the best interest of the company?
No, it was not.
And would failing to put the company into bankruptcy and antagonizing HFG, would that have been negligent and potentially subjected people to harm?
Well, I'm not sure of the exact definitions of some of those words, but not getting into bankruptcy would have created a whole host of issues, which boil down to no additional funding likely coming into the company, which would mean people being laid off immediately and scrambling to deal with patients that were in beds and on ventilators. It would have been, really my worst nightmare as a CRO in dealing with a precipitous shutdown of a medical facility.
After the bankruptcy was filed, the bankruptcy court approved your continued engagement as the CRO, correct?
Yes.
And ultimately, the 363 sale went through to the stalking horse bidder, correct?
Yes.
And there were no patient care issues as a result, correct?
Not that I know of.
Thank you, Mr. Polari. We'll pass the witness.
Mr. Polari, this is Rick Lindsay. How are you?
Okay.
I represent Mr. Laughlin, Mr. Sassman. Can you hear me all right?
Yes.
And I have just a few questions for you. A&M, I'm going to say that for Alvarez and Marcel, if that's okay.
Yes.
All right. It was retained on or about November 18th of 2013. Is that correct?
Yes.
Now, when did you first have any conversations with anybody who purported to represent Restora?
It would have been sometime before we were formally engaged, negotiating the engagement letter.
Do you recall to whom you spoke?
It would have been the owners, Jason and Kip, or the investors. I'm sorry, Jason and Kip.
And in the engagement letter, it has hourly rates set forth for managing directors, directors, associates, and whatnot. Those are all accurate numbers, correct?
Yes.
Was A&M paid on a periodic basis?
Yes.
Did A&M receive all of its fees, to your knowledge?
I think we received fees that were acceptable to us, so we continued work. Many times we wind up taking a discount on some of those rates and some of those fees, but we continued work and we were paid accordingly.
Do you have any idea what the total amount of fees that A&M received from Restora was?
I don't, but I'll take your word for it if you give me a number.
I have no idea. I was just asking you.
No, my guess would have been over the course of this thing, it would have been in the mid six figures, $500,000, plus or minus a few $100,000.
Okay. Now, you are the managing director of A&M?
I'm a managing director of A&M, Healthcare Industry Group.
How many managing directors does A&M have?
There's about 30 of them in the healthcare group, and I think perhaps 350 worldwide.
Okay. And you served as CRO of Restora while it was in bankruptcy, is that correct?
Yes.
you actually had served as CRO of Restora prior to it going into bankruptcy.
I believe so. I have to look at the exact timing of the engagement letters, whether we were an officer, whether we were, the CRO prior to the filing, or whether we stayed as an advisor. There's just some nuance there from an exposure standpoint. But if I wasn't the CRO, I was acting as the lead restructuring advisor.
If a company document reflected that you had been appointed CRO of Restora, you wouldn't disagree with that, would you?
No, I would not.
And in the month of December and into early December of 2013 and early January 2014, there were several competing companies at least kicking the tires and purporting to show interest in Restora. Is that correct?
Yes.
And actually one of those was a company by the name of Solterra.
Yes.
And Solterra got so far down the line that actually you did receive the consent of Mr. Laughlin and Mr. Sassman in that filing if Solterra was the stalking horse. Is that correct?
I'm sorry. Could you repeat that?
Sure, I'm sorry. That was a awkwardly worded question. All right, Solterra, you remember that potential stalking horse?
Yes.
All right. That deal, or that potential deal, got so far down the road that the petition for bankruptcy and whatnot had been actually prepared by DLA Piper. Is that correct?
I don't know if the two were directly related, but if there's a draft that reflects Solterra as a stalking horse, I'm not going to dispute that. But the DLA Piper preparations would have been in process anyway, because one way or another, the company was going to be in bankruptcy by mid to late February, either to create a liquidation, an orderly liquidation scenario, or to have one of these guys show up as a stalking horse.
Okay. And DLA Piper was serving as bankruptcy or restructuring counsel. Is that right?
Yes.
All right. And I'm assuming that it was not unusual for the attorneys of DLA Piper to have direct communications with the officers and managers of Restora.
Correct.
So, you may not know the answer to this question, but I'm going to ask it anyway. Do you know if Mr. Laughlin signed the authorization to file the petition for bankruptcy if Solterra was going to be the stalking horse?
I do not know. I don't recall, or I don't know.
And the same question for Mr. Sassman. You don't recall?
I do not.
And the actual stalking horse that with the petition that actually got filed was a limited liability company by the name of PHX Hospital Partners. Is that correct?
I'll take your word for it if that's what's in the documents. I don't remember the specific details.
All right, but you did recall that HFG was one of the participants in the Stalking Horse Consortium?
Yes.
And I believe you said a company by the name of Tutera?
Tutera.
Tutera?
Yes.
And do you know if Mr. Dodd was involved in that consortium?
Yes. I'm sorry, Jason.
Yes.
Yeah. I believe the previous owners were involved.
Same question with Kip Weatherwax. Was he involved?
I believe so.
Same question with Rod Laughlin. Was he involved?
I don't know. I think people may have parted ways after the board termination.
Same question with Mr. Sassman.
I don't believe he was. I think these guys all parted ways. But if the documents would reflect the ownership structure.
Okay.
So I don't know what they did, if they include guys or not.
All right, and you don't know, again, last two, Mr. Dunaway or Mr. Watkins?
Correct.
Now, you testified that you had several conversations with HFG during this time period from middle of November until the actual filing of the petition for bankruptcy.
Yes.
Who did you speak with at HFG? A number of people, or one person, or what?
There were Al Regdos was the principal contact, and then he had one other person. I just can't remember her name, but we were in contact with them. Like I said, it would have been at least once per week, probably much more. And they were in the information flow, as were all the constituents that were involved.
Okay. And do you recall anybody at HFC saying that they wanted to have management team removed at Restora?
Did you say HFC?
I'm sorry, HFG.
No.
And then the Chapter 11 bankruptcy actually was eventually dismissed. Is that correct?
I don't recall. I don't recall the dismissal.
Well, let me ask you this: were you involved all the way through the end of the bankruptcy, or did at some point A&M kind of ride off to the sunset?
We went into the sunset. There were something of an expensive resource, and it would have not been practical, I believe, to keep paying us. So we were.
You stayed involved until the 363 closing.
Yes, I think we saw that through, but then beyond that, typically companies don't want to keep paying for expensive resources once their deals are done. Okay. So we generally don't stay in touch or deeply involved. We're available for things like we're doing here today and other questions, but generally the answer is no.
So you don't know if the Restora is still in existence or whether it was discharged or whatnot in bankruptcy, do you?
I don't. I think one of my colleagues probably does, one of my junior staff who's charged with keeping track of these matters, but I personally don't.
And that's fine. I don't want you to guess. You just don't have any knowledge personally.
Correct.
Mr. Polari, thank you very much. I appreciate your time.
Okay.
Thank you very much for making time for us. I've got no further questions.
I don't have anything. Thank you for your testimony. Please enjoy the rest of your day.
All right. Thank you. Signing off.
Okay. We'll take a 5-minute break.